Hi, and welcome to the West Midlands Chartered Institute of Arbitrators event on NEC4 dispute resolution. I'm CIArb, and I'm the chair of the West Midlands Branch of the Chartered Institute of Arbitrators, and I'm a named NEC3 project manager on a renewable energy scheme in the water industry, and also I'm an accredited NEC4 project manager. Our event today will be conducted by Ian Heafy of In Construction Consultants and Sean Kennelly of Palm Commercial Services. Ian is a member of the NEC4 Contract Board and has been highly involved in the drafting and the development of the NEC4 suite. He has over 20 years experience in the construction industry, including aviation, oil and gas, rail, water, highways and building. He has worked with clients across the UK, Middle East, Far East and North America, including government bodies, private employers, international contractors, and he's experienced in most major forms of contract and is a recognised authority on the NEC suite of contracts. Ian has worked with the NEC in the development and growth of the contract and has supported numerous government departments, major clients, international contractors to deliver the benefit of the NEC. Sean is a chartered quantity surveyor, a fellow of the RICS, a fellow of the Chartered Institute of Arbitrators and a committee member of the West Midlands branch of the CIArb. Sean has been appointed as an NEC3/NEC4 consultant on various projects in the oil and gas, pharmaceutical, nuclear, civils, new housing and HS2. Sean's consultancy Palm Commercial Services currently supports projects in Europe, Dubai, Australia and Israel. Sean has acted as a party representative in 30 adjudications and is one of the first gold signatories to the RICS conflict avoidance pledge in recognition of his attitude to avoiding conflict and promoting conflict avoidance techniques. There will be an opportunity via the chat function to ask questions that will be answered at the end of the seminar. I'd also like to thank the head office of the CIArb who have supported the West Midlands branch in hosting the event, and please feel free to introduce yourselves in the chat function. Now I'll hand over to Sean to start the presentation. Thank you, Sean.
Thank you very much, Mia. So I'm Sean Kennelly, and it's good to see lots of attendance from lots of different countries around the world, which is very relevant at the moment, particularly when we look at the dispute resolution process in the NEC4 and in particular options W1 and W2. I'll now hand over to Ian, who will start the seminar today and start the talk. Thank you.
Okay, thank you, Sean and Samir, for those introductions. Welcome everyone to today's presentation. So what we're going to look at today is how to avoid and resolve disputes under the NEC4 forms of contract. I'm going to use the ECC, the engineering and construction contract, as an example of that, because that contains the greatest number of dispute resolution methodologies. As has already been highlighted, would welcome questions to be asked in the chat function, and then we shall answer those at the end. So in terms of the agenda for today, we're going to look at dispute avoidance techniques within the NEC contracts themselves. So how do we avoid getting into disputes in the first instance? We'll then look at how we have processes within the contract to bring matters to a conclusion and requiring the parties to either raise an issue as a dispute or to reach agreement. We'll then touch upon the dispute resolution secondary options available. And then finally, we'll give a brief overview of the dispute resolution service contract. And then finally, Sean will pick up some recent case law concerning NEC contracts that have a bearing on today's subject matter. So to start with then, the NEC contracts are designed to try to avoid conflicts, to avoid disputes occurring, and there are a number of clauses and processes built into the contracts to try to aid in that endeavour. So firstly, we have at clause 10.2, the requirement for the parties. So that under the ECC would be the client and the contractor. So the two parties to the contract, along with the project manager and the supervisor, shall act in a spirit of mutual trust and cooperation. So setting out at the very start of the contract an obligation to try to help each other, not to hinder each other, to try to work in support of the other's aims, though as guidance from the courts in the UK would suggest, that doesn't have to be to your detriment, but at the same time, you should not seek to take advantage of your opposing party, take advantage of any misunderstandings or misbeliefs that they are operating under. And there has been a recent case that's reinforced the legal weight of that particular clause, and that will be touched upon later by Sean. We also have the early warning process. So this is a process that features in every NEC contract, and it's a relatively simple process, but it's all about driving proactive risk identification and mitigation, placing an obligation on the project manager and the contractor to notify early warnings of a matter which may or may not, but which may affect time, cost, or quality. So the parties, the project manager, the contractor, have to notify these early warnings as soon as they become aware of them, and that then gives the opportunity to mitigate their impact through a process of early warning meetings. And it's important to highlight that those early warnings are notified not just for client risk events, those things that may become compensation events, but it's also an opportunity for the contractor to notify issues that are affecting them, that may be causing them to incur cost, that may be causing them delay, which may well be a risk that they are allocated under the contract, but they can still notify that, share it with the expectation that the project manager, the client, will look to help them mitigate their own problems. Very much going back to clause 10.2 and this concept of mutual trust and cooperation. So as we expect the contractor to come to the table in the early warning process to help the project manager and the client mitigate events that may become compensation events, reciprocally, we expect the project manager and the client to be helping the contractor if they're losing money, if they're suffering, hopefully resolving one of the key issues that causes disputes, which is somebody losing money, somebody not getting the return they anticipated under the contract. We also have the program. Program is at the heart of the NEC contracts, or certainly the main forms of contract, and there is a requirement for there to be regularly updated and issued programs that the project manager will then accept or not accept. But through that process of regularly updating, regularly resubmitting programs, that should give us two principal benefits. Firstly, it should create an accurate as-built record. So every month, or whatever time frame is set out in the contract that these programs are submitted, they should, up to that point in time, contain an accurate as-built record of what has actually happened. When they're accepted, we have that record. That in itself is a way of stopping problems coming up later, disagreements or arguments happening about historically what actually occurred. And also these updated programs will revise and reforecast the remaining work. And that will allow all the people involved to understand what's going to happen, when it is going to happen by. And if we have an accurate program saying when things have to be delivered, when people have to undertake certain actions, then it's much more likely that they will undertake the action and they will do it to the right time frame. Or if they are unable to do so, we can identify that failure and then we can start to address it. Another benefit of these up-to-date and detailed programs, it also allows us to try to identify potential problems. Are there pinch points in the program? Are there dates when certain things are expected to happen that are going to cause a difficulty for one of the parties? That may then lead to notification of early warnings, matters to be addressed through that process. So very much a key tool for managing the contract and anticipating problems or raising awareness of problems that can be then dealt with in advance. Final process we have then is the compensation event process. So this is the mechanism by which we deal with change. We deal with any entitlement the contractor may have to additional money or extended periods for construction. And so the idea of the process is to act proactively to drive this change management process, requiring us to notify the compensation events as soon as we become aware of them or within limited timeframes, and then having processes to deal with them. And at every stage of the compensation event process, we identify an owner of the relevant action, we identify a timescale for the action, we identify a consequence to deal with a failure to act. So we have a process that is going to, if you like, force the project manager and the contractor to address the issue, to deal with it, to drive it to a conclusion by allocating a responsibility and a time frame for undertaking or fulfilling that responsibility within the contract. We also look at all of these compensations in a consistent way, requiring people to address both time and money simultaneously. So we have to assess both delay and cost as part of that process. We can't leave time to be dealt with later, for instance, therefore possibly creating a snowball of issues and a global claim type situation. And when we assess the financial effect, we do so on the basis of defined cost plus fee, NEC terminology for actual cost plus a pre-agreed fee for overheads and profit. And that visibility, that approach of trying to base quotations on an actual cost basis, either as incurred or on a prospective basis to be incurred, should hopefully give the contractor compensation, should compensate them for the event occurring, which is not their risk under the contract. So the idea is those mechanisms as a whole should drive the parties to avoid disputes occurring. Should we move on to the next slide, please? So we have a quick poll for those in the audience. So from what I've talked about there and from your own experience, do you find that in practice, the dispute avoidance processes in NEC contracts do lead to a reduction in disputes compared to other forms? Or no, you find them not particularly effective and other forms have equal processes that deliver the same results? I'll just give you a moment to answer that.
Just give my view on this particular question, Ian. My view is that various processes certainly do help reduce disputes, and the requirement to attend risk reduction meetings and the strict timelines for programs and for pricing compensation events and assessing compensation events certainly do help to ensure that the issues are dealt with in real time and during the construction phase, as opposed to traditional and historical issues of dealing with all these issues at the end, or worse still, after the completion of the contract. Do you have any opinion on that, Ian?
Yeah, I mean, obviously the processes need to be used effectively, and so we do need users to follow those processes. But yeah, I do see them bringing benefit. The big benefit I see is it makes people it requires people to raise issues. They can't sort of hide issues or circle back later to try to pick up issues that weren't addressed or dealt with earlier. So it drives the parties to raise their concerns as and when they happen or soon thereafter, having to put on the table when things are needed, dealing with consequences as they occur. So hopefully we get a lot more honesty around the real issues under the contract and what is happening, and we don't have people trying to possibly rewrite history post the contract conclusion.
I think it's good to see that from the results that we got here, 73% say yes and 27% say no. I suppose that the no answer could be the subject of much debate, but generally I think the consensus is that yes, the NEC does help in reducing disputes. So I think that's a good indicator.
Yeah, I certainly think it's a positive response that we've had there. Interesting to understand the no's, and I see there's a couple of comments coming through the chat function that we can perhaps pick up at the end when we go through the Q&A, because it will be good to understand why people feel the processes detract from the issue avoidance or dispute avoidance, rather than maybe on neutral or positive. So hopefully people can raise some questions around that when we get to the Q&A at the end. Okay, we can move on to the next slide. So we've spoken about dispute avoidance, and there may be some who hold up the NEC as being a way of avoiding problems and everyone will get on great and there'll never be any problems. But that's not the reality. You know, even with NEC contracts, things can and do go wrong. Problems can be encountered, unexpected events occur that need to be dealt with, and they may well lead to increased costs and or delay. And so we then need to look at how we deal with that in terms of, you know, whose risk is it? How do we mitigate it? How do we evaluate it? And problems can be encountered because people don't follow their obligations, don't do what is required. In particular, we can find that people don't act as stated in the contract, that people fail to follow the procedures, the timescales, people don't act in terms of undertaking actions, giving instructions as may be necessary, and that can cause problems. And obviously, any contract is a way of allocating risk between the parties, and there may be a risk allocation initially agreed, but perhaps the parties may not have fully understood that. There may be tweaks or changes that have been made to the contract that then gives people maybe a different view over how risks should be allocated. And so even with the best will, there will still be disputes and problems under NEC contracts. Just go to the next slide, please. Another thing that can be a major cause of problems under the contract is where we have Z clauses that have been drafted that do not fit well with the standard NEC conditions. Often people will, want to change the contract clauses. There may be reasons to add additional clauses in, not necessarily an issue. What can be more problematic is where people use the Z clauses to amend the existing conditions of contract. And that generally tends to happen when somebody wants to reallocate risk or wants to try to alter the processes to maybe favor one party over the other. And so that can then lead to unexpected consequences, conflicts, and a lot of NEC disputes that I get involved in do tend to revolve around Z clauses that have changed the standard conditions of contract. Another thing that we often see in practice is that there's sometimes a disconnect or a conflict between the various documents that constitute the contract. So we may find that there are errors in how the contract data has been put together that doesn't then tally with how the contract itself should operate. I can remember one example where a contractor, rather than tendering a fee percentage, included a lump sum amount, which meant that you had a whole host of issues trying to operate the contract in practice due to the incorrect completion of the contract data. And also we can see within the scope that people may try to address contractual matters, may introduce requirements, processes that again can conflict with the standard conditions of contract. And so real care has to be taken to put those documents together to make sure they do comply, they are consistent. And then we may well get disagreements over the evaluation of compensation events. It may be that if there is a delay, if there is a change to the prices, that the project manager and contractor cannot agree on what the evaluation should be. And in the perfect world, yeah, great, they'll hopefully negotiate, come up with a figure, a delay period they can both agree with, but that may not always be possible. There may be a valid difference of opinions, in which case we may then need to go through the dispute process to get the entirely independent third party of the adjudicator or the dispute avoidance board to give a view on that, where there is this disagreement between the contractor and the project manager. And linked to that is where the parties fail to operate the contract mechanics in sort of real time, where they fail to do prospective assessments of compensation events, where people maybe either deliberately or tacitly agree to do things retrospectively. We then get this snowball of unagreed events combining together that then makes it difficult to unpick each of the events individually, to deal with them in the order in which they've occurred, which that can then make it difficult to follow the contractual processes. Just a couple of things to highlight that have been introduced in NEC4 that try to bring matters to a close, or if you like, bring them to a head if there is disagreement. There are now a couple of processes to try to get final agreements of the commercial issues under the contract and related to that issues around delay, etc. So firstly, we have a process that allows the contractor to inform the project manager that a part of defined cost is ready for final review and final agreement. The idea being that the contractor can inform the project manager that the defined cost for a part of the works, or maybe for a period of time, is complete. All of the invoices, the accounts have been dealt with, and so the contractor can put that forward for final agreement. So the project manager then has the opportunity to inspect the records in relation to that element of defined cost, and they have to review and respond within a 13-week period. So there's a reasonable time there for the project manager to undertake the audit, or they may delegate that action to others. During that process, the project manager can either accept the defined cost as being correct, they can request more detail where there's insufficient information being provided to justify the defined cost, or they can notify the contractor of any errors within that defined cost. Contractor then has to resubmit any information in addition that's required, or to correct any errors within a 4-week period. Upon receipt of that additional information, the project manager has a further 4 weeks to either accept it, or they will correct it as they believe is required. And one of the key things to understand, particularly from a project manager's perspective, is that if the project manager fails to respond to either the original submission within a 13-week period or the submission of further information within a 4-week period, that will be treated as acceptance that the defined cost is correct. So there is a need for the project manager to be aware of their duties under this clause to make sure they undertake the necessary audits. So the idea being that once the defined cost is treated as being correct, it is then no longer subject to audit. The project manager can't reopen it to disallow costs. The contractor is unable to claim more costs in relation to that element. It is closed, it is fixed. We can now move forward. The other part of the final assessment process is covered by clause 53 in the ECC, and this requires the project manager to make a final assessment 8 weeks, to make a final assessment 4 weeks after the issue of the defect certificate. So the defect certificate is issued at the defect state or at the end of any ongoing defect correction period. Defect state is going to be maybe 6 or 12 months after completion. So we have quite a long period of time within which we get, during which we have chance to settle issues before we get to the issue of the defect certificate. But 4 weeks after that, we have the project manager making a final assessment of the amount due to the contractor and certifying any payment that may be due. They have to give
sorry, Ian, and just with regards to the 4 weeks there, is 4 weeks an adequate period, especially when we consider that the NEC4 is used on lots of major projects?
Yeah, it's a good question. And in terms of the time period, 4 weeks is seen as a reasonable period, given that it is 4 weeks after the issue of the defect certificate. That defect certificate is issued at the defect state or possibly later if there's defects correction period ongoing. And that defect state is normally 12 months after completion. It could be 24 months. It could be 6 months. But there's normally a gap, a defects period between the completion of the whole of the works and the defect state, which is the earliest date the defect certificate will be issued. So that hopefully gives time to settle outstanding matters. Given that if you followed the contract correctly, you should have dealt with all of the compensation events, issues over disallowed cost if you're under the cost reimbursable payment options during the construction period, and maybe there's a bit of a runoff into the period between completion and the defect state, but most things should have been resolved during construction shortly thereafter. So 6-12 months later, when the defect certificate's being issued, you would hope that most things will have been resolved, and this is really just a confirmation of what's already been agreed, a way of bringing a commercial closure, as opposed to having lots of issues outstanding at this late period in the life of the contract. So say the project manager will make the assessment, they have to give details of their assessment, and the client will make any payment that becomes due. If the project manager fails to make that assessment, so if the project manager does not make the assessment, then the contractor is able to make their own final assessment. They don't have to, but they may calculate what they believe is the final amount due under the contract. They will send that assessment directly to the client, and the client will then, if they're happy, make payments with it, or if not, they will have to start a dispute process to challenge it. So the idea is that through either the project manager doing their job and issuing the final assessment, or if they fail to do so, the contractor doing it for them, we should have a final assessment issued. And then the critical part of the process is that that final assessment is treated as conclusive evidence of the final amount due under the contract, unless one party starts the dispute process under the contract to challenge it within a 4-week period. So within 4 weeks of the issue of that final assessment, you either accept it, and silence in this case will be deemed acceptance, or you challenge it. And that's not you simply write back and say, I disagree. This is that you start the relevant dispute process identified within the contract. So you start referring the matter to the senior representatives under W1 or W2, or you refer the issue to the dispute avoidance board under W3. So you have to actually take a positive step. Well, you may see it as a negative step, but you have to start actually undertaking a formal dispute process within that 4-week period. And again, sort of going back to what Sean raised earlier about, is 4 weeks enough? That 4 weeks after the defect state, we have the final assessment. Only 4 weeks after that is the final opportunity to challenge it. Well, the reality, I think, is that in practice, if the parties are maybe negotiating a settlement, if perhaps there are issues outstanding that are being addressed, there is nothing stopping the client and the contractor looking to extend those timeframes, looking to agree to a longer period. And one of the ways they may choose to try to resolve any issues disagreed is through a negotiation prior to the senior representatives process. So there's nothing stopping the parties working to try to resolve issues without necessarily pressing the trigger on a formal dispute process. But they do need to make sure that if they're not going to comply with the contract, that is being captured, that is recognized, so as to not lose the opportunity to challenge it at a later stage. Sorry, just go back a slide. So just turning to the dispute resolution options under the ECC. Under the ECC, we have 3 options. Options W1 and W2 feature under most of the main contracts in the NEC suite. W3 only appears in the ECC. So there is a choice of these 3 options. The client will select which one of these will apply in contract data part 1. And the client can only select one of these. In the UK, if the work that you're undertaking is covered by the Housing Grants Construction and Regeneration Act, then you would have to select W2. You would have no choice due to the requirements of the Housing Grants Construction and Regeneration Act. You would have to select W2 as your chosen dispute resolution methodology. If you're working outside of the UK, and a number of the attendees at this webinar are based outside of the UK, or if you're in the UK but undertaking work that is not considered as construction for the purposes of the Housing Grants Construction and Regeneration Act, you then have the opportunity to select W1, W2, or W3. Though the NEC would say, if you have a choice of W1 or W2, we would recommend you choose W1 because we think it works a bit better than W2. W2 had to be drafted in a certain way to meet the requirements of the legislation. W1 is freed from those requirements, and so we believe generates a better process to adjudicate. And so we would recommend, if you're not covered by the Act, to pick either W1 or W3. W1, W2 are very similar. They both feature adjudication as the primary means of dispute resolution, though, as I say, W1 is, we think, slightly better because of a dispute reference table that it contains, indicating who can raise what disputes at what time, with time limits in relation to them, whereas W2 maintains the right for either party to adjudicate at any time. W3, new in NEC4, that involves the use of a dispute avoidance board, and I'll talk a little bit more about that process in a moment. So moving on then to look at W1 and W2. So both of these feature an initial issue resolution process before we get to adjudication. So the parties are able to refer the disputes to the senior representatives first to enable them to try to negotiate a settlement. Under W1, it is mandatory that you have to take the matter to the senior representatives first before you can adjudicate, whereas under W2, it is optional because we still have to reserve the right to allow either party to adjudicate at any time. So the senior representatives process, mandatory under W1, optional under W2, though we do tend to see it being utilised under W2. So the idea of the process is that senior representatives are identified in the contract data. So the client will identify its senior representatives, contractor will identify their senior representatives, who will be called upon to negotiate a settlement if a dispute occurs. And the idea is that these senior representatives should be senior enough to have the ability to negotiate, to strike a deal, to try to get the matter resolved, and that they should also be removed from the day-to-day operation of the contract. The idea is that they're going to give a more holistic view of the issue, that they're not going to be coming to the table to negotiate with the baggage of, you know, what's happened on site, the history of the problems, maybe ill feeling between the parties. The idea is these people are one step removed. They can take a more open approach to it. They can look at it with a fresh pair of eyes and maybe be more amenable to settle than those who have perhaps been having lots of difficulties and arguments at a site level. Senior representatives can be changed by either party at any time if there's a change in personnel, etc. In terms of the process they follow, so the idea is there is a formal preparation stage where the contract requires each side to submit a statement of case limited to 10 sides of A4 together with supporting evidence, though the parties could agree to extend that, to change that. But the idea is we have a sort of default of the information to be provided, and it is limited in its content. And then on the back of the exchange of those statements of case, we then move into a 3-week period to try to negotiate a settlement. And it is exactly that. It's a negotiation. There is no structured process. it's down to the senior representatives to agree how to proceed. They may want to get a mediator in. They may want to ask for an independent third-party opinion. They may simply want to get around the table and just, go through the arguments and try to come up with a negotiation. But the idea is that there's complete freedom for the senior representatives to negotiate a settlement. It may not be the right answer contractually. It may not be, strictly in accordance with judicial precedent, but it's going to be a negotiation, in effect, a commercial agreement that both parties can live with, shake hands, and walk away. If they can't agree within that 3-week period, a resolution, or if some things have been decided but others remain unagreed, then those unagreed matters, the matters not resolved, can then be taken to adjudication. And important to note that the contents of those meetings, things disclosed and discussed, are on a without prejudice basis, therefore allowing the parties to, and their senior representatives to be fairly open as part of that negotiation process, maybe make concessions that will not then be raised or brought up when you go through a formal dispute process later.
Sorry, Ian, just to add into there, I mean, what's the point of this process if the parties can bypass it at any time and go straight to adjudication? And how likely is it that the parties adopt this process and agree to it?
Yeah, so it's a fair point that under W2, it is only optional. That under W2, the parties have a right to adjudicate any time, so they could simply bypass it, or they could start it and then partway through abandon it, notify the issue as an to adjudication. So, why have it? Well, I think that it is still seen as a good option to have, that whilst the parties could choose to ignore it, we do commonly see people try to use it as a first step in the process. Adjudication can often be seen as a bit of a negative thing. It can be seen as sort of bringing relationships into a very bad place. And also, the parties are giving away the ability to resolve their own dispute. They're giving it to a third party to decide on their behalf. And so often it's seen as a benefit to try and keep control of the dispute within the parties, to negotiate a settlement, avoiding the costs, the problems, the ill feeling that may come through an adjudication process. And, in fairness, this process was introduced even in W2, partly due to user feedback, that these sorts of processes were being adopted on other contracts, were being added in as Z clauses into NEC contracts using W2. And so we've just tried to bring in the opportunity for that process to be adopted, though of course we can't make it a mandatory process under W2.
And I think my experience also, as you said, certainly on larger programs of work and certainly internationally, it seems to be good practice anyway. And even though this didn't exist in NEC3, it was introduced on lots of contracts via a Z clause. So I think it's certainly beneficial to the industry.
Again, maybe we'll get some feedback on that when we get to the Q&A at the end of the session. Okay, so the next thing to look at then is if we can't agree through the senior representatives program, we're then going to move into adjudication. So we can move to the next slide, please. So W1 and W2, both of these dispute resolution options give the use adjudication as a way of resolving the dispute. An adjudicator, as I'm sure most of you are aware, is a truly independent third party. So somebody who is jointly appointed by the client and the contractor, independent of them both, who will then give a decision in relation to the disputes that they are asked to resolve. The adjudicator can be named in the contract, and if so, it will be the client who will name them in contract data part 1, or they can be appointed when the dispute arises. And it's often the latter rather than the former that occurs. Often adjudicators are not named in the contract, partly because if the client names somebody, the contractor may have a concern as to why has the client chosen them? Are they somebody the client knows or has a relationship with? Will they be truly independent? And probably more, a greater reason is that they may not be able to act when required. Given that when an issue is referred to adjudication, the adjudicator has to be appointed in 7 days, it means that that person has to be almost sat around doing nothing, waiting for a dispute to be referred. Commonly, if they're named, issues referred, they're then going to find themselves too busy to deal with it. And so you will have to appoint an adjudicator as and when you have a dispute, and that can be either through agreement, though if you get to this stage in the process, the parties often cannot agree what day of the week it is, never mind jointly agreeing who should act as the adjudicator. And so we have a default for an adjudicator nominating body, again identified in the contract data, to nominate an adjudicator if they are requested to do so. The contract requires them to be appointed under the dispute resolution service contract, which I'll touch upon later. How often that occurs in practice is something we will touch on again later, but that is what the contract states should happen. And we also have the opportunity for disputes between the contractor and subcontractors to be joined into an adjudication under the main contract by agreement. So under W2, very similar under W1, but under W2, the adjudicator can review and revise any action or inaction of the project manager or supervisor relating to the dispute, and they can alter a matter which has been treated as accepted or correct. There's various default acceptance processes under the contract. If one of those has occurred, it can be sort of overturned. The issue can be replayed in front of the adjudicator. The adjudicator can take the initiative in ascertaining the facts and the law related to the dispute, but they do have to comply with legal guidance around how they then engage the parties around that, how far they can go in that regard. And they also have the ability to instruct a party to provide further information and to take actions necessary to enable the adjudicator to make a decision or to do so within a stated time. And if a party fails to carry out the action, the adjudicator can draw any inference from that as may be appropriate. Adjudicator has to make the decision within 28 days. So it's a very quick process, which is actually in keeping with the sort of NEC logic, not just driven by the requirements of the Act, though that 28-day period can be extended by agreement. And then the decision of the adjudicator is binding, but is not necessarily final, in that the parties can, if they wish, appeal the decision, take it to the tribunal for a final decision to be given. So if a party is unhappy with the adjudicator's decision, if they're both unhappy, which would seem a strange scenario, then either or both could take the matter to a tribunal for final determination. So in terms of how does an adjudicator make their decision? Well, in accordance with the contract is the primary requirement. They need to look to the contract, obviously, understand the contractual allocation of risk, the contractual mechanics for evaluating changes to the prices, assessing delay, etc., and make their decision in accordance with the requirements of the contract. So they will apply the same sort of logic as the project manager should have applied. So if they're assessing delay, entitlements to money, they use the contractual mechanisms that are that are described within the contract. There may be governing law, the applicable law that they have to consider in their decision making. They're going to have to work within the time frame available, and they have to act fairly and in accordance with the rules of natural justice, using the powers granted to them under the terms of the adjudication provisions. Okay, we can just move on to the next slide, please. So turning then to W3, so this is a new process brought in NEC4, and this allows for the engagement of a dispute avoidance board. And the idea is that the members of the DAB, the dispute avoidance board, are appointed at the start of the contract, and they are regularly involved. They undertake site visits, they're copied into correspondence, so they are kept up to date with what is happening. They are therefore given the opportunity to try to understand any problems, to try to anticipate issues, and then work with the parties to resolve them. The contract allows for either a 1 or 3 person DAB to be appointed. I think, our view would be that it's normally going to be 3. That would be the sort of optimum approach, but it may be due to size of the project, maybe issues over affordability, that a single person is appointed to act as the DAB. If it's 1 person, the client will select the person, which again may possibly detract from its effectiveness if the contractor then has concerns over the person the client has appointed. If it's 3 people, the client will appoint 1 member, the contractor will appoint another member, and then they will jointly agree the 3rd. Therefore, trying to provide a better balance over who the members of the DAB are, with potentially a sort of independent 3rd forming part of that decision-making body. So the idea is the DAB members should be independent of the parties, experienced professionals with the sort of gravitas to command the respect of the parties, to be able to proactively work with the parties and each other to identify issues, and then to try to give recommendations, guidance over how to try to resolve them. So the idea is these are sort of, learned experts, people who command the respect of the parties, that the parties will be prepared to listen to and to take on board the recommendations they give. And they're working as sort of quasi-mediators, trying to get the parties to resolve problems. They're trying to preempt problems before they occur, maybe flagging concerns, issues that they can see on the horizon, issues they've perhaps addressed on previous jobs, and they're trying to help the parties negotiate, follow the contractual processes, whatever is necessary really to try to avoid disputes occurring by getting the parties to resolve the issues between themselves. If the parties can't agree a settlement, if they can't deal with the issue between them, then they can ask the DAB to give a recommendation. And so that recommendation is not binding on the parties. It is only a recommendation. It will be made in accordance with the terms of the contract, but the idea is it's a recommendation over what they advise should be done to settle it. It may be suggesting a commercial settlement. It may be suggesting something that is out with the strict contractual procedures if they believe it is going to get a fair result, one that is acceptable or should be accepted by the parties. So they have sort of freedom over what the recommendation looks like. It should be the best recommendation that they believe will enable a settlement to be achieved. If the recommendation is not accepted by either or both parties, then the parties can take the matter to the tribunal for a final binding decision. And perhaps just worth noting that although W3 is designed to be used outside of the UK, or where the requirements of the Housing Grants Construction and Regeneration Act do not apply, NEC has issued a practice note suggesting how you could use a DAB for contracts that are covered by the Act by using the DAB as an alternative to the senior representatives, a way of trying to introduce the DAB to proactively identify and mitigate disputes, but without losing the right of either party to adjudicate at any time.
Just to give a quick opinion in relation to what you just said, Ian, I believe that W3 is an excellent step and makes the NEC4 more effective compared to other international standard forms of contracts. I've reported to DABs internationally, but not in the UK. Is there an opportunity for the recommendations to be binding in W3, either in the UK or internationally, do you believe?
It's not how the process is intended to operate. I mean, obviously people could, via a Z clause, amend it to try to give a binding, to make the decision of the DAB binding. But we were sort of resistant to do that when we put it together, because the feeling was, well, if you wanted a binding decision, you can use adjudication. This is something different. This is a more consensual process where you're trying to work out your differences. The DAB acting as somebody to try and help mediate, help resolve disputes, as opposed to somebody giving definitive sort of decisions. And also, if we'd have gone down the route of it being a decision-making body, then you bring in things like requirements of natural justice. You then have to start to bring in limitations over what they can do and how they can act. And the idea was to give the DAB freedom to work with the parties how they see best to try to avoid disputes occurring. And ultimately, if there is a dispute that can't be resolved, well, you go straight to the tribunal, you get a definitive decision through that process. To go through an adjudication would seem unnecessary as a step in that process, but if you're using it with W2, you would have to go through that step.
That's useful.
Okay. So in terms of the tribunal is again something decided by the client in the contract data. So the client will decide when they put the contract together what the tribunal will be, and it's either going to be arbitration or litigation. Obviously, we're talking here on behalf of the CIArb, so most of you will be familiar with the concept of arbitration. Arbitration is commonly used in cross-border cases or where local courts may not have expertise in the matter in dispute. It's confidential. There's flexibility of procedures. Various institutional bodies will produce different rules to be followed, and you can have a panel of 1 or 3 arbitrators, possibly more depending upon the procedures followed. So that is commonly used as a dispute resolution method where perhaps, as I say, the courts locally haven't got expertise in the nature of the contract or the law surrounding construction disputes, and provides that confidentiality around the matters that are being disputed and any award that is given. The alternative to arbitration is litigation. So via the courts, where you will have a single judge appointed, and the benefit here paid for by the court, by the government of the locality. They'll use precedent in decision making, though often arbitrators will use the same to guide their decisions. The judgment, though, will be public. Evidence will be made available. The decision will be made available, quoting elements of the information that's been provided, so people will know what was disputed and what the decision made was, and there are procedures that need to be followed in terms of that process. The tribunal is often used in the UK because we do have some very good judges with expertise in construction sitting within the courts, though obviously CIArb and other organisations can bring to bear some very skilled arbitrators to resolve disputes under the arbitration mechanisms. Okay, final thing I'm going to touch on, then hand over to Sean in a moment, is the dispute resolution service contract. So this used to be called the adjudicator's contract in NEC3. It was renamed in NEC4 as the dispute resolution service contract because it can be used to appoint an adjudicator or a member of a dispute avoidance board. And that is to be appointed to act as an adjudicator, a DAB member under any of the NEC contracts or any contract. So you could use this with other forms of contract, not just NEC. It covers the obligations, methods of communication, payment, rates, expenses, timescales, and termination. In terms of the specific duties of the dispute resolver, that will be set out in the dispute process in the contract between the parties, which the dispute resolver is being appointed to deal with. So maybe a quick poll here, just wondering whether any of you have ever used the DRSC, whether you've actually been appointed under that form or you have appointed somebody under that form.
But I think it'd be good to add, Ian, that in this instance, it's very difficult to try and get adjudicators to change their standard terms and conditions. And unfortunately, most threaten to resign if the parties don't accept their standard terms and conditions. So I'd suggest that there's a lot more work required by the AMBs to encourage the use of the DRSC and other similar forms. But in your experience, have you seen the DRSC being used widely?
I have to say I haven't. I think you're right that adjudicators commonly will have their own terms. They've used them previously, they're comfortable with them. They will, sort of roll them out as and when they are going to be appointed because, they may have certain experiences they want to reflect in their conditions. It may be that they're being appointed under various different forms or to resolve disputes under different forms, and therefore maybe don't want to tie themselves to a specific contract. So we've got the results, and that's a pretty resounding no in terms of using it, 98% to 2. So maybe one for the NEC to take away and think about then the practicalities of that. But again, maybe we can touch on that as part of any Q&As at the end. Okay, I think on to the next slide.
Okay, thank you, Ian. So we've got 3 cases summarised here. So the first case is the case of Transport for Greater Manchester via Kier Construction from last year, and this covers the notification of an intention to challenge an adjudicator's decision. It is extremely important to ensure that notices are served as required under the NEC contracts. Notices are an important part of the contractual process, and the parties must understand the process. Although this case is related to the NEC3, specifically W2.4, it is worth mentioning that both the NEC3 and the NEC4 are almost identical, with minor drafting updates, such as the term "he" is updated in line with the gender-neutral language used throughout the NEC4. So in this contract related around the NEC3, the W2.4 covers the review by the tribunal, and we note the tribunal is in italics, which means that it has specific meaning in the contract data. In this instance, contract data part 1. So W2.4 states that if a party is dissatisfied with an adjudication decision, he or it, as defined under the NEC4, must serve a valid notice to refer it to the tribunal, whether the tribunal is litigation or arbitration, and that has to be done within 4 weeks. If a valid notice of dissatisfaction is not served within 4 weeks, the adjudicator's decision becomes final and binding. And if we go on to the second case, which is the case of Fraserburgh Harbour Commissioners v McLaughlin and Harvey Limited. In this case, brought to the Scottish court session last year, it was confirmed that the parties must adjudicate before a dispute is referred to a tribunal. The decision related to option W2 in an NEC3 contract, which was actually the ECC, and is the dispute resolution procedure when using the UK Housing Grants, Construction and Regeneration Act. W2 has been amended in the NEC4 ECC by the addition of a new provision for referral of disputes to senior representatives if the parties agree, but in regards to adjudication, it remains the same. So in the ECC clause W2.2, it provides that a dispute arising under or in connection with this contract is referred to and decided by the adjudicator. A party may refer a dispute to the adjudicator at any time. This case highlights that in an option, using option W2, this shall apply and the parties must adjudicate before starting proceedings before a tribunal. And we go on to the last case, which is the Van Ord v Dragadas case. And there's been lots of debate with regards to the NEC3 Clause 10 obligations for the parties to act in the spirit of mutual trust and cooperation, and whether this actually achieves anything. There was a recent appeal for the Van Ord v Dragadas case, where Van Ord acted as the dredging subcontractor on the Aberdeen Harbour Extension project. Dragadas removed approximately half of the value of the subcontract and awarded it to 2 other subcontractors. In the initial trial, it was held that Dragadas was entitled to reduce the subcontract price in accordance with Clause 63.10 of the ECC. Clause 63.10 states that the prices can be reduced if the event is a change to the works information or a correction to an assumption made by the main contractor when assessing an earlier compensation event, and the effect of the compensation event is to reduce the defined cost. However, on appeal, Van Ord was successful in stating that 63.10 did not apply since the instruction was a breach of subcontracts. And Van Ord relied upon the wording in clause 63.2, which states that the prices are not reduced except as stated in the subcontracts. The appeal court stated that the clause 10 duty of mutual trust and cooperation reflects the general principle of good faith in contracts, And as a result, there are three principles established from this case. The first one is for the contracting party not in normal circumstances be entitled to take advantage of his own breach as against the other party. And that's from a case from 1988, which was reiterated in this case. The second point, a subcontractor is not obliged to obey an instruction issued in breach of contract. And this goes back from a case from 1876, which formed the Birmingham Commonalty of London. And the third point is that clear language is required to place one contracting party completely at the mercy of the other. And again, this goes back to our case in 1949. So there are three other interesting points summarised in this case. So firstly, it means that all breaches are treated equally. None produces a reduction in the prices. Secondly, it avoids the suggestion that Van Ord was bound to obey a breach instruction. That cannot be right. To take an example, it would have not been under any obligation to build a new swimming pool if Dragadas had issued such an instruction. And finally, the NEC3 or the NEC4 should not be a charter for contract breaking. So that's that slide.
Okay, so I'll take over the Q&A. So we've had quite a few questions from the chat function and also from the Q&A. I'll just go through some of the questions that's been typed up. So the first one, if I can see, is from under the NEC3, if a quote is given at a compensation of issue but rejected, can the contractor update to include costs not initially contained in the revised quotation 9 months later?
I think you need to look at the concept of the quotation process is to compensate the contractor for the costs that they have or they will incur as a result of the event. So the idea being when the quotation is put together, it should contain all of the costs the contractor has or believes they will incur as a result of the event occurring. If, through the process of issue acceptance, non-acceptance, the contractor finds that there's things that they haven't included that are actual genuine costs that can be claimed, then I don't see any reason why they couldn't be put into a further quotation. You may ask why weren't they captured in the first instance, because the first quotation should have included a forecast of costs to be incurred. But if something was missing, then it could be added. In the same way, if something was included that was incorrect, it could be or it should be removed. What we're ultimately trying to get to is a quotation that represents the defined cost the contractor has or will incur as a direct result of the event.
Okay, anything to add, Sean? Or Ian's covered everything?
No, I think he's covered anything.
Okay, so another question. In the 4 weeks project management review period after the contractor resubmission, if the information provided by the contractor is not to the project manager's satisfaction for a decision, what will happen next? What should happen next?
So is this, I guess, in relation to the settlement of defined cost and the 4-week period for the project manager to review information submitted on the back of the initial review where maybe they found information wasn't provided or there was errors? So the idea is that the project manager within that 4-week period will try to, close out any of those outstanding issues. But if information isn't provided or errors aren't corrected, the project manager will in effect make their own assessment of the amount of defined cost. They will correct any errors. Now, there's nothing stopping the project manager within that 4-week period engaging with the contractor, trying to make sure that any missing information is provided. But if the contractor fails to engage, does not provide it, repeats the same errors in the information, then the project manager will have to correct it and the project manager's corrected value will become the determined or the accepted amount of defined cost.
Okay, thank you. Another sort of comment question. In terms of the final decision on delay matters only, JCT requires a decision by a deadline of 12 weeks after practical completion, compared to the NEC, which allows a much longer period, for like 4 weeks after the end of defect. Is this an accurate observation? And if so, it is interesting.
I can take that one, Ian, if you want. So this is comparing obviously NEC versus the JCT contracts. I suppose it's important to add a note that clause 61.3 of the ECC states that the contractor must notify you within 8 weeks of becoming aware that the event has happened. So I think that probably puts the NEC into a better place, since it's imposing a potential time bar in the event that the delay isn't initially notified by the contractor. So obviously by the time you get to completion, if everything works okay, then the delay should be resolved via the compensation event quotation process. So I think that's a good question.
Okay. Next question. With reference to W2.1, the drafting committee made comments that the unfettered right to adjudicate at any time does not always assist parties to resolve dispute and should be reconsidered. Do you two either have a view on this and how this could be reconsidered? Is there any other better options or solutions?
It's a good question. And, going back to what I said earlier, that in W1, the sort of preferred adjudication process, if you ask the drafters of the NEC, that does contain this issue resolution or this issue notification table, where you decide or you list the matters that can be referred to dispute, who can refer them and how long they have to do so. So the idea is compliant with like the logic of NEC, that we want people to be proactive to make decisions. There either is an issue and a dispute or there isn't. And by leaving it to be adjudicated at any time, it could be that someone could adjudicate, 6 months later for something that happened earlier. Whereas if you have a time frame in which you need to take the action, that is going to drive parties to make decisions to either decide to act or not act. So the idea is it brings a bit more structure, discipline, and a time frame which is seen as beneficial, though there could well be a counter argument over, well, what if that deprives somebody of a route to justice if they're not getting the matter dealt with? But of course, there is always a recourse to a tribunal ultimately under W1 and W2.
Okay, I'll move to the Q&A. So, what can you say about the NEC's global reach? Could you please advise the name of the countries other than the UK, South Africa, Hong Kong, Peru, New Zealand, that the NEC suite of contracts are being used?
Okay, well, I think you've probably hit the main ones there. The reality is that the NEC is only produced in the English language. We don't produce any translated versions, which potentially limits its use in countries where English isn't the language of business. And also there does seem to be a little bit of a Commonwealth type vibe going at that. It tends to be used in countries that have historical links with the UK. So certainly, South Africa, you've got New Zealand, you've got Australia, where it's being used now with Sydney Water primarily. Yeah, you've got Hong Kong. So these are sort of countries links to the UK, common language of business. It has been used in the Middle East. So it was used in Dubai and Abu Dhabi, though it's not been used recently in those locations. It has been used in India. It has been used in Sri Lanka, some other countries like that, though where it tends to be used is those countries where, as I say, the language of business tends to be English. There is a major scheme in Belgium that is using it, a multi-billion euro project, and it has also been used in the Netherlands. Interestingly, in Peru, it's been used extensively in Peru for infrastructure around the student games, and it's being more widely used by the government. and there it has been translated into Spanish. So we do see a non-English language version being used in that location.
Okay, one of the comments from just come through is in terms of, do you see that it might be difficult to sort of explain the ethos of the NEC, especially how it's developed in the UK, why it's harder to actually introduce it to sort of non-English speaking, non-Commonwealth countries?
It's a good question. I mean, firstly, just to maybe sidestepping the initial question for a moment, the contract is written in sort of simple English. That's the intent of the wording. So the idea being that it should be easier to understand if your first language isn't English. So to sort of understand it, to be able to translate it should be easier. Whether that actually happens in practice is interesting, because I was involved in helping translate it into Dutch for the project I mentioned in Belgium, which was interesting. So in terms of, does the ethos stop it being adopted? I'm not sure. I think wherever it's sort of gone, into the UK initially, people said, what does what is now 10.2 mean? You know, I remember some of my very first NEC contracts, lawyers advising their clients to delete clause 10.1, to delete the reference to mutual trust and cooperation, because nobody knows what it means. It's not very good drafting. You know, we don't have that in the UK. And yet now people expect it and understand it and accept it. In Hong Kong, when it was first introduced, same arguments. What's this nonsense around mutual trust and cooperation? Get rid of it. We don't need it. It's not going to be, that's not how we do things here. And so that cultural resistance, that sort of climate of dispute, of distrust, I think exists in a lot of countries. And it's more a cultural change that happens when you use the contract. And it's probably broader than just having the contract itself. It's having that desire to try to change the industry approach, such as Sydney Water are doing in Australia now, and using the NEC to facilitate it. Places like the Middle East, some other countries, it can be more difficult to introduce it because there maybe is, you know, slightly different cultures. But even there, you know, there's a lot of openness, there's a lot of opportunity, I think, to get people to try to see the benefits it can bring.
Okay. On a question from an associate member who wants to actually understand, when it comes to NEC disputes as an arbitration adjudicator, what's the typical sort of profile of those people, and also what special skills and the application, or is it the application of NEC knowledge which makes a good NEC4 adjudicator or arbitrator?
Okay, do you want me to take this one? I'll take it initially. Maybe Sean, you got some views to share on that. So I think in terms of the skill set needed to be an adjudicator, I guess to act as an arbitrator, if that's the chosen tribunal, yeah, one of the primary things for me is knowledge of the contract. You need to understand how the contract works, how things like delays should be determined, how the change to the prices should be calculated. So yeah, knowledge of the contract, I think, is fundamental. Obviously, you then need to understand the process you're operating under, so the rules that govern the duty you're undertaking, and then obviously knowledge of the wider law as it applies to the contract, as it applies to the issues in dispute generally, and in the powers you're able to exercise in the capacity of adjudicator or arbitrator.
And on that, in terms of the split, the sort of discipline, do adjudicators tend to be engineers or quantity surveyors, lawyers? Do you see a mixture of all, or does one sort of profession take the majority of?
I think I can contribute to that with my experience acting as party representative. I think it's a mixed bag, really, and depending on which A&B you go to, obviously there's lots of different A&Bs. Predominantly perhaps at the ICE there's a lot of engineers, at the RICS there's probably a lot of quantity surveyors, at TEX are a lot of lawyers, but generally speaking, you know, each A&B there's lots of different categories, but also adding to that with regards to adding to, I think, experienced users are traditionally, you know, you can't be an adjudicator on something that you haven't got excellent experience of, and more often than not, experience does take many years and lots of projects. So I don't think it's going to be a role that you'd fit into after experience on a couple of NEC projects, especially with NEC being quite different to the other standard forms of contract being available.
Okay. One question here is the power to change something that has been treated as accepted useful? Does it not create real problems?
Yeah, it's a good question, and I can see the sort of logic behind that. That yeah, if you've gone through the process and maybe there's been a default acceptance of a contractor's quotation, or maybe just through the quotation process we have an implemented impact in terms of the effect on the prices all the time as a result of a compensation event. If we allow it to be reopened through an adjudication, does that create more harm than good? I think the issue you have is that there may well be mistakes that happen. It may be that the project manager fails to correspond in time, maybe doesn't understand their duties, and a quotation that is quite frankly wrong gets accepted by default. It would be unfair for somebody then to have to sort of comply with that if it was, grossly unreasonable and it was only accepted through a failure in process. The idea of things like default acceptance is to try and bring a conclusion. That doesn't mean we should never look at it again. It means that we have a discipline, a process, an end to the process itself. But then there should always be, I think, that right to challenge it if it is patently incorrect.
Okay, good question here, actually. Interested to hear that the PM and contractor must look prospectively, but often they don't. If they don't, which is unfortunate given the intention, can the parties look retrospectively to determine entitlement?
I guess two parties to a contract can do anything they choose as long as they mutually agree to do so. And I do see in a lot of instances the conversation on the lines of contractors saying, oh, it's a bit too difficult to try to prospectively assess this. Could be 6 weeks, could be 4 weeks delay, could be X, could be Y in terms of cost. Why don't we wait and see? And the project manager or the client may think, oh yeah, well, why don't we? Problem with that is you're going to then work on a almost like a cost reimbursable basis. You're going to give them the actual delay. You're going to pay the actual costs. Where's the incentive for efficiency? And it always makes me, slightly smile that you imagine that at tender stage, the contractor has to estimate the cost of the whole job. They have to put together a program for the whole of the job at tender stage. And yet partway into the job, we get a compensation event, maybe a couple of weeks of additional work, maybe a bit more money, and suddenly we can't estimate it, we can't assess it, yet we could do the whole job at the very start. I think we're either kidding ourselves that we can accurately estimate the whole price of a job at the start, or we're not giving ourselves credit that we can do the same estimates at a later stage. Though, as I say, I do see it happen. Sometimes, it can be a way of avoiding arguments about what could happen. But, I think people should work to try to make the prospective process effective.
Okay, I think it's come to the end of the event. So I'll just ask one more question. Sorry,
Samir, would I be able to deal with, I know there's a question surrounding contract administration leading to disputes, which I think was a good question. But obviously with the NEC, it does create a lot of contract administration. Some would say it's a burden, but of course this would be possible on all types of contracts. But I think it's good to add that the use of cloud-based systems does help keeping and tracking registers, and it's they spit out functions of what's up to date and what's not up to date in relation to compensation events in relation to the programme. But obviously what we're trying to do is ensure that we work harder during the construction phase. So if it is going to create an admin burden, then there's no better time to do it than during construction, as opposed to waiting to the end of the project. And certainly we don't want to be arguing after the contract's ended, because that will only result in far greater costs being incurred by the parties. So although a lot of people say that there is an admin burden created by the NEC, I'd like to think that's one of a very good advantage of the NEC.
Okay, all right, and this is the last question. So failure to comply with the NEC early warning timescales could in itself create dispute, particularly where the substantial costs and complex changes are at stake. What's your viewpoint on that?
I suppose I have to understand the context of that, in that early warnings are meant to be a means to an end. You notify an early warning to give the opportunity to mitigate the time and cost effects. If there's a failure to give an early warning and the opportunity to mitigate is lost, then that can be taken into account in any assessment of a compensation event, possibly a disallowed cost under options C, D, E and F. But any costs to be disallowed or not included as part of the compensation event quotation or delay would have to be delay or cost that could have been saved. So you would have to have a reasoned argument that that failure did cause something. And then, yeah, could that cause a dispute? Well, you know, that event or that situation would cause a dispute under any contract, that somebody failed to take an action to mitigate a potential loss. If a loss is then suffered, there's often arguments around whether actions could have been taken to mitigate it. In the NEC, we have a very specific action that should have been taken, an early warning, but I think you'd still have a similar argument under other contract forms where there was a failure to mitigate a potential issue.
Okay. Right, just one final question, I'll just squeeze it in. Some contractors try to tender low, win contract and then make money using CE process by giving inflated quotes. This is something that needs to be looked at in later revisions.
I'm not sure that's something that the NEC could address. I mean, you know, that's a sad reality. And for me, that's much more around how you engage the supply chain, how you undertake your tender evaluations. We do need to try and get people to be, if you like, more honest at the tender stage. You know, it's difficult to try to mitigate that problem that if people choose to underbid or bid at or loss, you'd like to think the tender process would spot it. But if it happens, and it does, then yeah, you're going to be facing a difficult situation under any contract with a contractor trying to recover the loss. I mean, one of the benefits maybe of using the cost-based options, payments on a cost reimbursable basis, that you get visibility around some of that, and the contractor will potentially, you know, get some of that loss recovered through a pain share, gain share. But, you know, I think that's more the, you know, trying to change behaviours and tendering processes than something you can actually rectify post-contract through clauses in the contract.
I suppose just to add on to that, you mentioned behaviours, but at the end of the day, the NEC, although it tries to create good behaviours, it does take two to tango. If a party doesn't want to act, it doesn't want to, it's got poor behaviour, then you know that would be the case in any contracts. At the end of the day, the NEC tries to encourage good behaviours, but in terms of forcing good behaviours, no contract can, unfortunately.
Okay, so on that basis, I'd like to thank Ian and Sean for presenting this slide. It's been very interesting, and also to Nika and Katrina in helping us to support this event. The West Midlands branch, with the sort of advent of COVID, had some advantages that we're now doing virtual events, which is open to the wider sorts of ADR community. We've got a few events sort of planned on delay and disruption, a mediation workshop, an arbitration workshop, adjudication case law update, and potentially site visits to construction sites in the West Midlands. So some of our seminars will probably be done virtually, and our workshops will be done in person, hopefully without any restrictions with regards to COVID. So please keep on referring back to the CIArb website for any updates, and also the West Midlands branches have a LinkedIn page. So if you do want to know more about the branch and get involved, or have any suggestions for a future event, please feel free to contact me. So on that note, thank you all again for attending and listening to such a great presentation. Thank you.
Thank you
Very much.